Hey guys, this is Vijay Dinakar. Today I want to talk about whether a domestic violence victim can drop a case. Now, a very common question I get after somebody is arrested for domestic violence is, my husband or my wife or my boyfriend or my girlfriend doesn't want to press charges and they want to drop the case. Can't they just do that? And the answer, generally speaking, is no. So just to sort of rewind a little bit, going back to a domestic violence arrest, usually the police are called, they come to the scene, they interview both people, the husband, wife, boyfriend, girlfriend, and if either one of them says that they were hit, they are required by California law to mandatorily make an arrest. So a lot of times when the police come, let's say the wife or the husband says after calling the police, I don't want him or her to be arrested. I just want him or her to be warned. And the police will say, sorry, ma'am, sorry, sir, we are required by California law to make an arrest. And I'll often see in the body camera after the fact that the wife or the husband is literally screaming or crying, telling the police they don't want the arrest to be made. But again, there is a mandatory arrest. They have to make that arrest. So at that point in the case, the arrest stage, there's absolutely no ability of the victim to stop an arrest from going forward. After that, the case then goes to the district attorney's office, the prosecutor, who makes a decision about what, if any, charges to actually file in court. And then before that pre-filing stage, the question is also asked, can I drop the case? Can I tell the district attorney I don't want this case to go forward? Again, the answer is generally no. It's not the victim who is pressing charges. The district attorney is filing charges at their discretion if they think enough evidence exists that the domestic violence offense was committed, and they are usually doing that in spite of the wishes, oftentimes, of the victim. Now, the district attorney will consider what the position is of the victim. But generally what the district attorney is most looking at is the actual evidence of what occurred during the incident. Now, a lot of times victims call the police in anger, they're upset, they want to get the person in trouble, and some of what they said is either simply false or exaggerated. So it's at the point after the arrest that oftentimes victims do submit new statements to the district attorney, which are more accurate. And those statements will be considered by the district attorney in deciding whether the case is going to be filed based on the evidence. But again, to say that it's up to the victim to decide whether the case is going to be dropped is simply not correct. Now, if the case is filed, the case is now going to the pre-trial stage of the case. Again, at that point, if the victim hasn't submitted new evidence, either through an investigator's statement or through some other evidence of what actually occurred, they can certainly do it at that point. And again, that may well influence the district attorney to make a decision to dismiss the case. But it's, again, not up to the victim to make that decision. It's up to the district attorney. Their position on whether they want the case dismissed will be considered by the district attorney, but ultimately it is up to the district attorney. It's up to how severe the injury was, whether there's any past unreported domestic violence besides this incident. It depends on whether the subsequent statement that the victim may have made is more credible or less credible than the original statement. Now, going further, if the case cannot be dismissed or it cannot be resolved by way of plea bargain, the case may well go to trial. And then again, the question is often posed either by the victim or by the defendant, can this case be dropped at this point? What if they don't want to testify in the trial? So that question is a very good question. And before 2008 in California, the answer to that question was that if a victim is subpoenaed, meaning issued a court order to come to testify about what happened at the trial, that victim must come to court and they must testify. If they refuse to testify, meaning if they got on the witness stand or before getting on the witness stand, they told the court, I'm not going to testify. I'm not going to put my husband or wife or boyfriend or girlfriend in trouble. They could be held in contempt and put into jail. So in a very normal criminal case or even a civil case, if somebody is lawfully subpoenaed to come to court and testify as a witness, and they refuse to do that, that is an instance of contempt, and they can be put into jail by the judge until and unless they stop that contempt, meaning they actually get on the witness stand and testify. Now, in 2008, the California legislature changed that rule with respect to domestic violence victims. So now, post-2008, because of California Civil Code of Procedure 1219B, a victim of domestic violence who refuses to testify cannot be put into jail. So as a practical matter, they can be actually fined civilly, but they can't be put into jail. So a lot of times you do see, and I have seen many times, where an alleged victim of domestic violence does refuse to testify after being subpoenaed, and they are not held into contempt, they're not put into jail, and then the question is, then what happens? Then does the case get dismissed? It may or may not, because obviously, or maybe not obviously, domestic violence cases can be prosecuted without victims testifying. I mean, the most obvious example of that would be a domestic violence murder. So someone could be murdered during a domestic violence incident, and that obviously does not mean, because that person can't testify, that the case is going to be dropped or dismissed. In a case where the victim does live but is unwilling to testify, either because they can't be subpoenaed or because after being subpoenaed they refuse to testify, the question is, what kind of evidence in terms of that alleged victim's statement could be heard by the jury? And the answer is, after 2004, with the case of Crawford versus Washington, the law says that generally statements made by an alleged victim to the police are not admissible to be heard by the jury unless that person testifies, meaning they've had a chance to be confronted by their accuser, the defense attorney of the defendant. However, there's a little bit of an exception even to that rule, because after the Crawford case, some of the statements were ruled by the court to be allowed to be heard by the jury if it occurred during what's called an ongoing emergency. And the most obvious example of what statements a victim might make to the police during an ongoing emergency would be during the 911 call. Because during the 911 call, especially if it's occurring either at or right after the point of the alleged domestic violence incident, we're going to have the emergency still being ongoing. So what does this mean as a practical matter? It means that if the victim either cannot be found or comes to court and refuses to testify, and the district attorney decides not to dismiss the case at that point, and let's say the victim had called the police during an ongoing emergency, well, then the jury might hear the 911 call, they might see the pictures, but they will not be able to hear the police officer repeat the statement of the victim because the victim is not in court to be confronted by his or her accuser. So I think this has generally answered the question about whether a victim can drop or retract or have a case of domestic violence dismissed if they want to. If you guys have any other questions, let me know. Take care and all the best.